This is the ERISA Edge, bringing you fast, insightful, actionable advice on fiduciary responsibility and retirement plans. I'm Don Jones, and our meaningfully different discussion today will focus on decision by the Supreme Court ruling 9-0 in a case called Casey Cunningham et al. Versus Cornell University. What has occurred is so significant that if I were going to put it on a Richter scale, an earthquake, this is at least a 10, unless you are doing what's right in the plan. When ERISA was established in 1974, it was established under two principles. Orthodox format. That means just do what the law says. Don't reinvent it. Don't water it down. Don't do what you wish it was. Don't decide it's unfair. It's also written in what's called black letter law. And that also means that you are doing what is established in the courts. What amazes me is all these court cases that are coming down, they look the same, but the industry doesn't make a change. They alibi it, or they don't know what they're doing, or it's called willful ignorance. They don't want to know. Almost everyone in a retirement plan that smiles and says they love you do not actually want to do black letter law. You see that because case after case after case, they lose. And then you hear them bellyache. Well, quit bellyaching and just do black letter law. How big is the Cunningham case? It's a monster. For those of us who are 402 fiduciaries, we are held to a standard of what we know or ought to know. We spend probably 3 to 5 hours a week just studying what is going on and making a decision of whether it is a 1 on the Richter scale. We still need to be aware of it. Or is it a 10? Well, if you're going to be a service provider under ERISA, you need to know 3 cases so well. One is Tibble versus Edison International, landmark case. The second was Brotherston versus Putnam Investments. And the third was Hughes versus Northwestern University. But the Cunningham versus Cornell University now goes up to number 2. Other than Tibble, it is the most powerful, earth-shaking change in ERISA, and it didn't need to happen. The justices throughout the process said, this is not new. In fact, they said, just follow the law. So I've already said it's a 10 on a Richter scale. And SCOTUS, the Supreme Court, ruled 9-0. There was no question about it, which to me is almost saying you're wasting the time of the court. Just do what ERISA says. You may not like it, but just do it. Yes, it's orthodox. Yes, it's traditional. Yes, it's black letter law. But those are the rules of the game. Now, what's unusual about the case that I've never seen is once they ruled in favor of the plaintiff, the participants and their beneficiaries, they told exactly what a plaintiff needs to do in order to get past the judge dismissing the case, so that it can now go to discovery. But what's unusual about it is after they gave the formula, they then turned around and said to the defense, now we want to talk to you to make it fair, to balance it. We're now going to tell you what you need to do, that even though you didn't get your way in getting it dismissed, what you need to do to have such a solid case that the plaintiffs aren't going to win. Now, my question today is, will the financial industry take this seriously? Because they have the formula now. It's very clear what they need to do. Now, I'm not going to get into all the detail today, but you need to know it. And you need to call someone like Fiduciary Wise that has always practiced in the culture of orthodoxy. But let me give you a few takeaways before we leave for today. There is no question, plan participants and beneficiaries, as far as the Supreme Court, the highest judicial law in the land, that the participant is innocent and the defense needs to then prove after discovery that they're not guilty. This is completely different from what we see in the courts in America. The second thing I'd bring up to you is the court has also given what we refer to as prohibited transaction exemptions, but they must be done correctly. You can't just pick and choose what you want to do or leave it out. Now, just to tell you how significant that is, there's 21 statutory exemptions, and then Congress gave the right to the Secretary of the Treasury to add others. I took a quick look the other day, and there, if I counted correctly, there's 114 different categories of exemptions. And if you drill down, they average about 8 or 10 then individual exemptions. Yes, they're individual, and it must apply to your plan. So that's nearly 800 or 900 other exemptions. If you're going to work with someone, the only way you're going to get out of jail free if you're a plan sponsor is to be able to show that you dotted the I's, crossed the T's, didn't do what you thought it ought to be on any one of the 900 or whatever PT exemptions. You're going to hear more words like causation, affirmative defense, statutory PTE exemptions, guardrails, Federal Rule of Civil Procedure 7, and much more. Now, let me bring it down to today. Not only did the Supreme Court rule, but now they are getting in contact proactively to the Office of the Solicitor General of the United States to say, hey, you ought to go back and look at these cases. Well, in conclusion, be very sure that who you work with is not doing what they wish it was. They're doing what it is. Well, I want to thank you today for watching the ERISA Edge. Be sure to follow Fiduciary Wise for more insight on fiduciary responsibilities and retirement plans. And stay tuned for our next video.